If you ask someone to, define disability in a workplace, most people instinctively picture a wheelchair ramp, maybe a visual impairment.
For sure.
But we're doing a deep dive today using this ultimate guide from HTW Law, and it shows that the legal landscape in Ontario is way, way different.
It really is. When you dig into the Ontario Human Rights Code and some of these WSIB policies, you realize the legal definition of disability is just massive.
Right.
It covers everything from, physical injuries to mental disorders, learning disabilities. And the biggest misconception, the most dangerous one, is thinking you can refuse to accommodate someone because it's a business inconvenience.
And that's the hook, isn't it? Because in practice, almost every accommodation is an inconvenience to some degree. It changes things.
Of course it does.
But the guide here is crystal clear. Legally, inconvenience is totally irrelevant.
It is explicitly not a factor. We're looking at Section 17 of the code. It says employers have this duty to accommodate up to the point of undue hardship.
Okay, undue hardship.
But the courts have a very, very strict list of what actually counts. There's basically 3 things.
Only 3.
Yep. Cost, any outside funding sources, and health and safety requirements.
And that cost has to be huge, right? We're not talking about a small budget hit.
No, not at all. We're talking about a cost so high, it would basically threaten the whole business.
Right.
So if a manager says, we can't do this, it'll slow the team down, they've probably just handed that employee a discrimination case.
Wow. And Section 10.1 makes the definition even wider.
It does. It's not just physical things you can see. Which brings us to the Entrop v. Imperial Oil case. That was a total game changer for addiction in the workplace.
Right, that's the one that basically said substance abuse is an illness. It creates a physical or mental impairment.
Exactly. So legally, an employee with a severe alcohol dependency has the same rights to accommodation as an employee with, say, a broken back.
But the guide points out something here that I think most people miss.
Oh, this part is key.
The code doesn't just protect people who currently have an addiction or even a history of one. It also protects people who are just perceived to have one.
That's the mind-blowing part for a lot of managers.
It is. You could be totally sober, never touched a drug in your life. But if your boss thinks you're an addict and fires you because of that belief, that's discrimination.
Yes. The law is targeting the employer's behavior, the stigma. If you act on a stereotype, you're liable.
So, okay, let's say someone listening feels like they're being targeted. How do they prove it? The guide brings up the Mizetish approach.
Right, from Mizetish v. Value Village. It's a 3-step test, and the bar is actually pretty low for the employee to start.
What's step 1?
1, do you have a protected characteristic, like a disability? 2, did you suffer adverse treatment? You got fired, demoted, something negative.
And 3 is the link, the connection. Was the disability a factor in that treatment?
And it doesn't have to be the only reason. It just has to be a reason.
Just one factor among many.
As soon as you prove those 3 things, the burden of proof just flips instantly. Now the employer has to prove that accommodating you would have caused that undue hardship we talked about.
Which is, like we said, a very high bar to clear. Okay, I want to shift to something that probably affects, half the workforce right now. Stress.
Burnout.
Yeah, we use that word burnout all the time, but WSAB has very specific categories.
They do. They separate traumatic mental stress, say, from witnessing a horrible accident, from chronic mental stress.
But there's a huge catch with chronic stress claims, isn't there? Specifically when it comes to management decisions.
This is a vital distinction. You generally cannot claim benefits for stress caused by standard employer decisions.
So if your boss fires you or changes your shift and you have a mental breakdown over it, that's usually not covered.
Correct. Those actions are seen as just part of the job, part of the employment contract.
And this is the important part. If that management action crosses the line into harassment, bullying, toxic comments,
then that exemption just vanishes. Harassment is considered a substantial stressor, and that can open the door for a claim.
It's all about that line.
And if you do win these cases at a human rights tribunal, the payout isn't just about lost wages. The guide mentions damages for injury to dignity, feelings, and self-respect.
So the law recognizes the emotional damage, not just the financial hit.
It does. It's about the human toll.
It really makes you rethink things. If the law protects even a perceived disability, are we maybe too quick to judge a coworker's performance issue as just laziness?
When it could actually be a health crisis. Or just our own bias filling in the blanks.
It's a dangerous assumption to make.
And one the law definitely does not look kindly on.
Something to think about before your next performance review, I guess. Thanks for diving deep with us on this.